Welcome and thank you for joining Seyfarth's virtual event, Ask the Pfml Expert, Q&A with DFML Director Bill Alpine. All participants are in listen-only mode. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Ariel Kudkowitz. Ariel, you may begin.
Thank you very much. Welcome, everyone. We're extremely pleased to have Bill Alpine, the Director of the Massachusetts Department of Family and Medical Leave with us today to answer questions that you have supplied us in advance. We have a lot of questions. We'll make every effort to get through them, and we know folks are already asking questions during the program. If we don't get to them, we will respond to them after the program. And so we'll get right to it, Bill, if that's okay with you. You also see I have my colleague Dan Klein here, and Dan and I are going to sort of tag team a little bit in asking questions. So, Bill, we're going to start with some sort of general coverage type questions. And the first one is, if an employee goes out on leave pending a claim to be filed with the state, does the employee have to take the time unpaid? Can the employee use time off, or does the state provide retroactive funds upon acceptance?
There's a 7-day waiting period, and the employee can use whatever leave they may have in the form of accrued leave, whether it be sick, vacation. The only point to make here is that an employer cannot compel an employee to use any type of paid leave.
Great, thank you, Bill. The next question is, can employees use paid time off to pay for the employee's contribution to the premiums during PFML leave if they're not collecting salary or cash or any payment from their employer?
In essence, if they were to use accrued paid leave to pay for the benefits that are offered by the employer to pay their share, that would, to us, look like they were receiving accrued paid leave at the same time as they're receiving a benefit, and that would not be permissible.
That's the answer I thought you were going to give, so I appreciate that. And then the next question is an email from the employee sufficient for notifying the employer of the need for leave?
This is an area where, we want to not get into the business affairs of an employer. Hence, employers should be updating their policies. And if that's an acceptable form of messaging to the employer, then, we're not going to question it. When we see an application from an employee, we're just merely looking for the date they inform the employer. And if during the process the employer says something to the contrary, then we'll certainly take that under advisement.
Great. Thank you, Bill. The next question pertains to bonuses. And the question was, the person understood that the law states that leave shall not affect an employee's right to bonuses. And the question was whether that means that employees need to be paid 100% of a bonus, or can a bonus be prorated in any way to account for the time that they're not present during approved PFML?
Again, this is an area that we really haven't come out with any guidance on. I would advise employers to consult with, counsel, HR professionals, because there's always that concern that you potentially have, which is the job protection, rights that an employee may have. So it's kind of tough for me to answer that. It's a pretty broad-based question, and that's kind of a response for that.
Understood. Okay, thank you, Bill. I'm going to turn to a question that regards the benefit year. As certainly you know, and as I think most of our audience knows, so I'll repeat it for them, the PFML defines the benefit year one way, which is the 52-week period commencing on the Sunday prior to paid family medical leave. So there's been some concerns about the lack of overlap between the PFML benefit year and the Fmla options for a benefit year, because none of the Fmla options have this sort of Sunday start to the year. In trying to see if there was a way for it to work for both, one of the questions that came up was, do you view the 52-week period as a fixed benefit year once that person has their first leave? Does it run for 52 weeks? And then if they have if they need to look at the allotment of leave, they're only looking at that fixed period until that expires, and then a new benefit year starts the first time they have leave after that expires? Or is it more of a rolling format where you're always looking at the 52 weeks backward from a leave once we've gotten in, past the first year?
I'll answer this with my description of how we're going to interpret the benefit year, but I do not think it's that last point that you mentioned, looking back. We base the benefit year on the date, the Sunday preceding the date on which an employee first commences the taking of leave, regardless of whether it's with the department or with some other program offered to the employee by the employer, short-term disability. So at that point, when that employee commences leave, and let's just say it's not with us, but it's with the employer, the benefit year commences then, and then it is the lapse of 52 weeks, and then the calculation starts over, entitling them to another up to maximum 26 weeks in a new benefit year.
And that would then start at the first time they take any new leave after the first year is expired?
Right.
Got it. Okay, that's very helpful. Thank you, and I really appreciate the added clarification that it's really any type of leave, not just if it's a PFML type of leave.
Any type of leave that's associated with a qualifying reason.
Understood.
That's a defined term. If they're using vacation, then that's not necessarily a qualifying reason unless it's for a qualifying reason.
Great. Thank you. Thank you very much. Ariel, you want to take the next one?
Yeah, sure. Bill, the next question is, when a teacher is on federal FMLA leave, school breaks do not count toward the employee's FMLA entitlement since they are instructional staff and the employee would receive their full weekly pay from the school. How would PFML work in this scenario?
We're not necessarily following how FMLA treats it. It's all how the applicant tells us they want their allotment. So as you know, if they were using or applying for bonding leave, it's 12 weeks in a benefit year. They could say we want 6 weeks now, 6 weeks later. So it's all, to us, it's all how the application is furnished. Is it we want continuous leave? Do we want to take it split? Do we want to take it on an intermittent leave basis? That's how we will determine benefits for any applicant. And again, with teachers, I assume it's in the private school university context because municipalities are excluded under this program unless they opt in.
All right, thank you, Bill. That's very helpful. The next question is sort of given the crush of fraudulent unemployment claims that we've experienced, is there any discussion of delaying the implementation of the PFML? We think the answer is no, but obviously look to you to give us clearer guidance if there is any.
Yes, as far as I know, we're moving forward with January 1st.
All right, thank you.
Thank you, Bill. So the next question regards the injured service member leave, that family member who's injured in the line of duty, which is provided which is provided in the PFML law and regulations as up to 26 weeks per benefit year. And we wanted to clarify The FMLA treats this a little differently, or at least expressly. The FMLA says that someone can take that 26 weeks one time per injury per family member in any single 12-month period. So if a family member is injured again in a different injury, they could take it again, but they can't take it every year for the same injury for the same family member. Would PFML have that same limit that you wouldn't be able to repeat the 26 weeks every benefit year for the same injured family member who may have a permanent or long-term injury in the armed forces?
Right now, we don't have the similar restriction that FMLA has, but that's an interesting point. We do try to mirror ourselves as much after FMLA as we can, but it's not something that we've specifically addressed in our regulations, and maybe at some point later on we might.
Understood. Thank you, Bill. Okay, we're going to turn topic-wise to a few questions relating to intermittent leave. This is a common question that comes up, a common issue that comes up a lot. Recently, we, Seyfarth, published a legal update about some recent information that we had seen on the department's website on intermittent leave and the increments that an employer could require intermittent leave to be taken in. And there was a mention of those increments not exceeding 24 consecutive hours as a minimum increment. And we understand that is no longer posted on the department's website, and it may have been a draft or something that wasn't intended to be released. Could you just clarify the status of that provision, if there's any clarification you could provide?
Yeah, it's still under development. We apologize for that getting out there. The policy, all in all, will be very similar to what you may have saw, with a few minor tweaks. But the 24 consecutive hour rule is likely still going to be part of that policy.
Understood. Thank you. Another question. The regulations, the Pfml regulations provide that intermittent leave shall be taken in increments consistent with the established policy of the employer or the covered business entity that they use to account for use for other forms of leave. There was some confusion that we've received from some clients about the Massachusetts Earned Sick Time Law has a little bit different of a standard in sick leave, that you can take it in increments that are the same as your timekeeping system would require. So that might get as small as tenths of an hour or 15 minutes, et cetera. We read this provision as being more akin to how do you provide intermittent leave under FMLA or other similar types of leave policies. But a client said, well, wouldn't sick leave be one of those policies? How do we know whether it has to align with sick leave or not? What are your thoughts on that?
We're just basically saying that for purposes of payment, it's 15 minutes. We're not going to pay anything below that or anything in between. And, you know, again, an accumulation of 8 hours before we can, you know, accept a claim for intermittent leave. It's more of an administrative aspect for us. You know, and that's, you know, as far as how it correlates with other laws like sick time, yeah, we're trying to, you know, we understand there's a consistency issue but as far as us, it's really a question about payment.
For the provision that says an employer can sort of set the increment, but it should do so consistent with its other leave policies, it sounds like it would be fair if the employer is at least setting that increment, whether it's a minimum 1 hour, or 2 hours, or 3 hours, whatever it's going to be, as long as that's not inconsistent with some of their other leave type of policies, whether it's a family or sick, family or medical type of policy. Is that fair to say?
I think it is, yeah.
Okay, thank you.
Great. Bill, the next question is, can an employer temporarily transfer an employee to a position with equivalent pay and benefits while the employee uses intermittent paid family and medical leave like you do under the FMLA?
Again, I go back to, are there policies in place allowing for such an action? And, you know, there's always that job protection element that, you know, an employer is doing something adverse to the employee in connection with the employee exercising a right under our statute. So, you know, I think it's really something that employers should evaluate. We haven't come out with any particular guidance on it, but we have come out with our regulations that, you know, touches on it a bit, that an employee is required to follow the reasonable policies prescribed by the employer.
And so if I'm hearing you correctly, if the employer, you know, has policies in place that permit for that kind of temporary transfer, you would look at that. You wouldn't look at that disfavorably.
We have nothing to do with the policies of the employer or how they're interpreted as far as job protection. That's done purely through court, and that's a cause of action between the employer and the employee. So it's not like we're going to be issued or requested or issuing any ruling on whether or not an employer's policy is permissible or not.
All right, thank you. That's helpful. The next question is, again, if an employee has multiple employers or changes employers, and they are on intermittent family medical leave, does that intermittent family medical leave follow the employee to their alternate or new employment?
It does. We have no termination provision that says when you switch jobs or terminate or separate from employment that your benefits end. No, we do not have that. So, you know, that's then becomes a discussion point with the employee and the new employer.
All right, thank you. So that's I think that's a really interesting point for people to think about how to have those discussions, how to initiate those discussions. The next question is, how will an employee manage intermittent leave with the state? Will they need possibly to submit sort of use allotments weekly, for example, or on some periodic basis?
As I said, so, you know, it's a 15-minute increment, 8 hours of accumulated time or 30 days before the first usage of time that hasn't been paid. At that point, the employer is already going to be approved for intermittent leave, let's just say. And then when they use the time according to the schedule, they're going to file a claim. We're going to look at it. We're going to probably correspond with the employer to see if the employer by chance paid anything to the employee for the time that's being sought in the application. There's no specific reporting requirements until the employee actually gets to us for filing a claim, and then at that point we're going to be looking to see when the time was used and most likely reaching out to the employer more for corroboration purposes.
Right, thank you, Bill.
So, Bill, we're gonna turn to one of what it seems to be one of the hottest topics that we get questions around all the time. Are the overlap or potential overlap with short-term disability, or some cases long-term disability, or other company-paid family or medical leave policies. We have always interpreted the law and the regulations reference to a reduction from Pfml for a permanent disability policy or program of the employer as including long-term disability. Is that a fair reading, that the reference to the reduction for a permanent disability policy or program benefit would include long-term disability benefits?
This is one of the things that we've struggled with, I guess, because I don't think there is any definition out there of a permanent disability policy.
Right.
We don't, it's in our statute, we know, but we're interpreting, and there's only two terms used, temporary and permanent disability policies. We're interpreting temporary to be short-term or long-term. As far as a permanent disability policy of an employer, we are not sure what that even looks like. And we've even consulted with members of the insurance industry on this, and frankly, I think they're uncertain on it too. I think it's something that may have used to exist, perhaps under workers' comp. I think there's, I've heard also that it really applies to the states that have TDI. I think there's only 3, Rhode Island, Hawaii, and one other one that escapes me. So we're interpreting short-term, long-term to be the same thing for purposes of allowing to supplement your PFML benefit.
That is really informative. Thank you, Bill, because my next question was about should we interpret the temporary disability policy to equate to short-term disability? It sounds like it's going to be, you interpreted the temporary disability policy is referring to not only short-term, but also long-term disability programs. Yeah,
and that was my inkling early on, but I was enlightened by the insurance industry and the groups that we work with. So, we received similar feedback from some insurance agencies, providers. So that's really interesting. And for the audience, just to clarify sort of what our understanding has been for the last couple of years, there is a reduction off of PFML benefits for short-term disability, and now it apparently is also for long-term disability if and when the employee gets up above 100% of their average wage. Then it would be reduced by the state for that short-term disability or long-term disability benefit to bring them to 100% and not get a windfall. In other words, as many of you are dealing with your policies, your short-term disability benefits can supplement PFML up to 100%, top up to 100%, but not more than that. And what we've learned today is that that is the same for long-term disability. It can supplement up to the 100%, and only then would it be reduced from PFML benefits by the state. That's really, really helpful. Thank you, Bill. One related question. There's a reference in the final regulations to a reduction for paid family or medical leave received from any source, in quotes, from any source, for any qualifying reason under PFML in a 12-month period prior to filing. One of the questions that we received was for the family leave for a serious health condition that doesn't take effect till July 1st. If a company in their private approved plan wants to offer that sooner, now, after January 1st, but prior to July 1st, based on this other source language, could that then offset or reduce any PFML taken within the 12 months after they've voluntarily provided this benefit early in those, January to July period, June period? This is an item that we're currently addressing right now. That I don't have a solid answer for you. I can probably say that for purposes of administering the state benefit, if it's family leave used during or after January 1st, we won't count it. Again, that's assuming somebody's on the state plan throughout. As far as the private insurance sector, we're looking at that to try to provide some guidance.
Understood. We appreciate that. Thank you, Bill.
All right, Bill, sort of continuing on that theme, there is some confusion, and we got actually a number of questions about this as to sort of logistically who pays first when paid family medical leave overlaps with short-term disability. Does the state pay the PFML benefits under the public program first, or does the company or the insurer pay short-term disability benefits under their plan program? And our understanding has always been that, in essence, short-term disability can top up the PFML plan, as Dan just talked about, up to 100%, but they run concurrently. But maybe you can shed some light on just sort of from a point of view of what happens first.
There's nothing that I've been able to put my finger on that says that we pay second. So we're taking the position that we pay first.
All right.
And then it's up to the carriers to make the determination as to what they pay off of that. Right now, there is no, we're primary. Whether it be by implication or otherwise, probably more implication. That's how it is right now.
All right, that's actually very helpful. Thank you, Bill. So it sort of dovetails into the next question that we received is, can an employer using short-term disability top off the state's PFML payment to make the employee whole, or does the employer need to provide the state with exactly what they anticipate to pay, and then the state pays the remaining up to $850? And I think if I understood your answer last time, that's not how it works.
Right.
Okay, so the state would pay its whatever it determines the benefits are, and then it's between the employee, the plan, and the employer for any remaining short-term disability benefits.
Right.
All right, thank you. The next question is, can you provide details on how employers can submit reimbursement claims? How does the offset or reimbursement process work? And we got that question from a number of participants.
Again, another area that we are working on as we speak. First of all, we're trying to define what a reimbursable plan is, because there's been questions about that. What is it? You know, and we're in the process of looking at that right now. And then as far as the actual process itself, it's likely going to require employees right now to also file a claim, because we have no idea. Our system is tied and our program is tied to employees. And without a reference to an employee, their name, social security number, date of birth, we need validation in that form. How that information comes into us right now is going to be an evolving process. Right now, it seems as though that's the process that has to work. We realize, you know, that's probably not the most preferred way. As time goes on, the employer should be able to apply through an employer portal, but that's not something that we're going to have ready for launch on January 1st.
All right. Well, you anticipated my sort of follow-up question to that about the sort of the portal access for employers. So because a number of folks have asked about that, so that's something that's being contemplated, but obviously won't be ready come January 1st.
Right. Well, the process itself will probably be ready, but it's going to require the employee's involvement as well. How that comes in, is it a call center type of claim? Is it through the portal on the employee side? I think the latter. But we're, you know, literally trying to still work these finer details out. Our main objective so far has been getting an employee's ability to file the claim with our ability to correspond and communicate with the employer.
And just to follow up on that Bill, I believe employers can currently register to sort of designate who their point of contact is going to be electronically with the department. Is that right?
Yes, they can, and we strongly urge that they do that. So if you haven't registered your leave administrator, you can now do it. You go to our website, mass.gov/DFML. I think there's a link to the employer portal. Yeah, and set up an account, please.
Hey, Dan, can I jump in a little out of order, which is sort of off that specific answer? Does that apply equally, Bill, to private plans? So for folks who have the exemption?
Yeah, we don't have a requirement that private plans register with us, although private plans eventually could end up having claims filed to us, particularly from the appeal standpoint. But right now, there is no, we're not looking for private plan leave administrators.
All right. Thank you.
That's helpful clarification. We have received that question. I also wanted to do one follow-up on the reimbursement aspect. I know the process isn't logistically set up yet, but one scenario that several clients have raised is if for some reason they've approved, for instance, short-term disability before they've heard back yet from the state on approval of PFML, and maybe they go ahead and pay more than they otherwise would have to pay, is that something that they would be able to seek reimbursement for if they've sort of gotten ahead of paying more than they needed to pay because of the PFML being the primary? Is that something they could seek reimbursement for once PFML was approved?
If it is a employer disability plan, and again, it's not a private carrier plan. It's a plan administered by an employer, more or less in the context of a self-insured
Right.
Policy, and they pay, then that falls within the purview of a reimbursement. Provided, however, that you cannot seek reimbursement where we have paid a claim for the same period of time that's being looked for reimbursement.
Understood. Yes, this is only if it turned out to be an overpayment, but that's a really helpful additional point you made, that it would really need to be a self-insured employer because it's the employer's spend, not an insurance company's. Thank you.
Yeah, and that's one of the things that we're trying to work out with the reimbursement, because there's reimbursement policies. There's also, there's also policy, when you get into the context of being able to supplement, and then there's the self-insured, that's a reimbursement. So these are the things that we're trying to really get to the narrow details, and the way it's looking, it's going to have to almost be two policies. What does a policy look like? And then here's the process.
Understood. Hey, Dan, just before you go on, a question came in on sort of communication with employers that I thought was just relevant to our last discussion before we move on. So the question is, if you don't have an online portal or a connection yet for employers on the online portal, how will you communicate with the employer if the employer does not have access to mail?
Okay, clarification. We do have an employer portal. We don't have the ability to take reimbursement claims through the employer portal yet. The employer portal right now is just more or less when we receive a claim, notice goes out via email, an application has been started by one of your employees. When the claim is finished by the employee, notification goes to the employer. There's a claim waiting for you to review. Furnish any documentation during that process. Once we receive the information, we then turn around a decision. Employer gets emailed again. Check your inbox in your portal, in your leave administrator account. So no, the employer portal does exist. It just right now is not capable of handling reimbursement requests from an employer.
Thank you for that clarification. Perfect.
Thank you. So another question was, this attendee, their company had an approved private plan for medical leave. And the question was, for employees who started medical leave in 2020 and exhausted the company paid medical or short-term disability leave and are now on long-term disability, would the employer pay short-term disability benefits again as of January 1st, 2021? My initial thought and response was, that's not something that's going to be determined by the department. That's going to be determined, obviously, by the company's short-term disability plan. Is that fair to say?
I think so. If the employee is on some form of disability prior to January 1st, 2021, it all then factors down to, are they then applying for a benefit with us from an event that occurred prior to January 1st, 2021, which is conceivably permissible. But that would then come into, our analysis as to whether or not the employee is receiving other sources of income, like a disability plan. But that's the department's role in all of this. But what an employer should be doing, I'm not sure I can answer it, because I'm not sure I fully understand the question.
Yeah, and I think where the question was coming from is, if the person's exhausted short-term disability, but suddenly on January 1st, Pfml comes to life, does that sort of reinvigorate short-term disability? And my thought is, no, it does provide Pfml medical leave rights, but that doesn't affect whatever's happening under the company's short-term disability plan.
Yeah, that's between the carrier, the employer, and the employee.
So a part of that set of questions from this individual also was, on a separate aspect, are prior short-term disability wages that may have been received in the last 4 quarters included in the department's determination of the average weekly wage?
I'm going to give the textbook response that if they're part of wages that are defined under the unemployment statute, 151A, Section 1, wages, then yes. We base everything on whether or not they are in fact wages under 151A. We don't make the determination, but we will look when a claim does come in to see if there were contributions made on that particular policy, which would mean that the carrier in that case would be responsible to remit contributions, which I'm not sure that that's happening. But it's wages that are subject to contributions.
Understood. Thank you, Bill. This next question, the individual said, if their company does not have a private plan exemption, so they're on the public program, but they offer a fully paid 6-week parental leave program, basically bonding leave, sort of 100% pay for 6 weeks of bonding leave, can they consider that to run concurrently with Pfml and apply for reimbursement from the state for the excess, for the piece of that would have been the Pfml portion up to the $850?
I'm sorry, Dan, I'm going to need you to repeat that. There was a lot there.
Sure. So this is a company in the public program that has a separate company-paid parental leave policy that provides 100% pay for 6 weeks.
Okay.
They asked if they can consider that to run concurrently with Pfml, which I think the answer is yes. But the separate question was, can they apply for reimbursement for what the Pfml would have been paid from the state?
If it's a plan that falls within the broad perspective of being a plan of an employer, then yes. Again, this is an area that we're coming out with guidance, and again, the additional caveat is that we won't pay if we've already made payment for the same period of time. But if they have a 2-week bonding policy that pays 100% of the wages, then assuming that policy has no greater restrictions than what the DFML program is, yeah, we would pay up to what we would have paid had the claim been filed directly with us.
Understood. Okay, we're going to turn topics over to the accrued paid leave section of the regulations and some of the issues that have come up there. Just as a reminder for our audience, for accrued paid leave, unlike with short-term disability or long-term disability, for accrued paid leave, which is PTO, vacation, sick, or personal time, if your company's under the public plan, then the Pfml cannot be topped off with that accrued paid leave. However, we did receive recent clarification from the department that under a private plan, then the employer can provide the employee the opportunity to top off Pfml with accrued paid leave. So, Bill, I wanted to give the audience that reminder for those that weren't familiar with that. But the question is, someone asked, why isn't there a top-off provision under the public program for PTO? They don't understand why employees can't use giving the employee the choice to use their earned time to top up to 100%. And they wanted us to ask you, and it's probably more a question for the legislature, I understand, but do you have any response to why no top off in the public program?
We took the statute to mean that there's only 2 situations in which an employee can top off, and those are the private plans of an employer.
Understood.
Yeah, we've had that question both prior to the program and during the program in our question queue. That has come up a couple of times. So it's an answer. It may not be satisfactory for our listeners, but it's from your perspective, it's derived directly from the statutory language. So we're going to turn next to maternity and parental related questions. So the first question is, does the short-term disability portion of maternity leave which varies from 6 to 8 weeks depending on the type of delivery that the birthing mother goes through. So is there, it's a tough question, I apologize, but let me start with a premise to maybe clarify it, Bill. But the premise is, of course, that short-term disability is not determined by your department, and that paid family leave for childbirth doesn't presume 6 or 8 weeks. It's just based on the medical provider's certification, and it could be potentially up to 20 weeks. Is that sort of a distinction that is helpful for our listeners?
We have 2 types of leave in that case. We have bonding, we have medical. The bonding is just that, to bond with the child within 12 months, for 12 weeks within 12 months after the birth or adoption. If there happens to be a medical complication before or after, it's a medical claim. While you can file these together, conceivably you could file the bonding or the medical first and then the bonding. We, unlike private insurance, do not equate bonding to mean disability or medical condition. A medical provider, with respect to the medical portion of a claim that could come in from somebody that's using bonding, must be supported by a medical provider's healthcare provider form that certifies that there's a medical condition. So straight bonding, it's 12 weeks. If an employee is requesting some form of medical leave, it has to be supported by that healthcare form.
All right, thank you, Bill.
Getting back to the top off issue, I want to make it clear that private plans can top off with accrued paid leave.
Right.
It's just a state plan.
Yep. Yeah. No, we appreciate and mention that distinction. Thank you.
So following up on sort of the maternity parental area, if someone delivers a baby, what happens if they wait 2 weeks from the date of delivery to call the state or to apply for benefits? This particular employer pays employees biweekly, and what are the implications if someone is overpaid?
If someone is overpaid for, I'm sorry.
So let me see if I can break it up.
It would be regular wages that they were paid while the employer was sort of, the claim had not yet been made by the employee. It was a 2-week delay before they went to the state.
Okay. Well, one of those weeks would be a waiting period, right?
Correct.
The second week would be technically leave that we wouldn't pay on, because they both would have been used to count towards the concurrent leave. I think that's what the question is. As far as an overpayment of the employer, yeah, technically the employer did overpay, but if we're looking at it, we're seeing wages that were paid.
Yeah, no, I understand that. It's not like it was paid for the leave purpose, so it wouldn't be offset from leave once it was approved. Understood. All right, turning to a different question. One company has employees who had parental leave in 2020, and they asked whether the employer needs to, for someone who, as we enter 2021, do they need to explicitly notify these employees that they can take more leave, more bonding leave essentially in 2021, or is it satisfactory that they've been provided the legally required notices, last year and the posters, et cetera? Is there any affirmative obligation to notify these people who have taken recent parental leave?
We have not established any affirmative policy or regulation requiring employers to notify their employees that they're entitled to additional leave on January 1st.
Thank you. That answers the question directly.
And Bill, then the last question in sort of this subset is, from a company who says that a representative, I assume it's either a leave administrator or insurance rep, has told one of our pregnant employees that she cannot access the serious health condition leave plus the bonding leave. Is that true?
No, it is not.
Right. I didn't think so. And how about is that access to the medical leave and the bonding leave, is that sequential, or can that conceivably be accessed at the same time?
If you have a medical condition that's related to pregnancy, and you obviously the medical condition, you can apply for the both leaves. It gets probably a little trickier if there's an event during birth that requires the medical leave. That person may have applied for the bonding and didn't know about the medical condition, so it would have to be an amended claim.
All right, thank you. That's helpful. We're going to switch now to everyone's favorite topic. We have a number of tax-related questions. So we'll start off sort of very generally. How are paid family medical leave benefits going to be taxed, and does it differ for approved private plans?
We don't know. That's a question that we've been trying to get answers to, and at this point, we have not. It's an IRS determination, and it doesn't necessarily, it starts with contributions, and how contributions are handled from a taxation standpoint, pre or post-tax. We think it's post, but again, the IRS has to rule on that. We're awaiting a determination. We're not alone. They're also trying to review and issue guidance for a number of these states that have either started or will be coming up over the next couple of years. So we don't know. We're alerting clients that the benefits may be taxable and that they should consult with a tax advisor. But it's from our standpoint, we don't know, and in particular, because there's different potential withholding situations. You have the medical portion that's required to be paid by the employer. Then you have the discretionary pass-ons to the employee as far as contributions. All of those could set up a different tax consequence from the benefits standpoint. So, we've heard this one. It's the question I first heard when I came in, and it's the question I'm hearing up until today. And it's unfortunate I don't have an answer.
Yeah, no, and I know, Bill, the department, you've been trying to get this answer for a while. So I know this issue, it's been out there on your FAQs for a while, and I know the request has been pending with the IRS for a while. So one follow-up question on taxes, and I think I know the answer based on your prior responses. Will the benefits be taxed now or when the employee files taxes in the following year with a 1099 form? And I suspect your answer remains the same. That depends on the IRS guidance, which you have not yet received.
Right, and it's not beyond the realm of possibilities that we do something on an interim basis, that maybe we just do automatic withholdings at some point. Unfortunately, that's an add-on to the claims processing engine that we're using, and it's not going to be ready for January 1st.
So, Dan, before we move on to the next set of questions, I want to give out the CLE code. So for everyone listening, so the CLE code is SS as in Seyfarth Shaw 7464. Again, that's SS as in Seyfarth Shaw 7464.
Okay, and we're going to try to move quickly. We've got about 11 minutes left. Turning to the topic of private plans and the issues related to private plans. One question was, a company had submitted a private plan application on September 30th. They received provisional approval, but are still waiting on the formal approval. What happens if they do not hear back by December 31st? Should they go ahead and administer their plan on January 1st, or are they at risk?
They should be reaching out to the DOR call center, and that will then come down to one of my staff members that handles exemptions. I'm curious as to why it's still provisionally approved. If you're saying September 30th, it sounds like a self-insured plan. Self-insured plans can be provisionally approved for a number of reasons. It could be that they didn't fill out and provide an insurance declaration document. Could be that they didn't provide a bond. Could be they didn't provide the right bond amount. They really need to be contacting the contact center, and there should be a number on that notice that went along with the provisional approval, or they should be checking in. I don't have the number off the top of my head. I'm sorry, but if you went to our website again, Mass.
No, that's fine, Bill. I'm sure
And please, don't wait till December 31st. If you haven't heard, there's obviously a problem. I'm assuming we've reached out to you, and we're in the process of revoking approvals on prior approved exemptions, both in the self-insured and fully insured context. So you don't want to fall into that because there'll be repercussions, back contributions, interest, and possible penalties.
Thank you, Bill. Ari, I'm going to turn to your next question because my last question was answered both questions.
Yeah, and actually, I'm gonna actually skip one because you answered it earlier, Bill. So, the next question is: can employers with a private plan take benefit deductions out of their paid family medical leave benefit that is paid through salary continuation?
Again, we're not doing it on our end. It's really something that employers have to, look into and get guidance on. It's not an area that we have provided guidance on at this point. But again, private plans can be, a better benefit. But I can't predict what an employee may raise as a cause of action as a result of an employer doing that. The benefit obviously has to be as good as whatever the benefit would have been with us. There's all these job protection concerns that an employer should be aware of, and they really ought to engage counsel, competent personnel in the process.
No, and I think that's actually, Bill, a helpful clarification for folks as they think through it, particularly as they think through how their plan compares to the benefit that they would get if they were under the public plan. The next question is: if we haven't already applied for a private plan exemption, is there time? And if not, what are the implications, fees, or penalties? So I think I know the answer to that, but I'll let you respond to that.
So the self-insured's deadline has already come and gone. It was September 30th. We're still working with employers, but at some point we're going to have to terminate those exemptions. And again, the repercussion is that there's back contributions owed along with the other, interest and potential penalties. The private fully insured plans have until December 31st, and there's no question we will be working on those well into January. If last year is any indicator, it's, we want to work with employers, we want to work with carriers. We're trying to be flexible. But if you don't respond to us or give us what we're requiring, you could go into that revocation process.
Thank you. But and for companies who haven't yet applied but are considering perhaps in the future applying?
Sure, you can apply anytime you want. It's effective the first day of the first quarter following the approval. Obviously, the longer you wait, the more you've contributed to the state system, and those monies remain with the fund.
Right, correct. Thank you. That's very helpful. Dan, I'll turn it to you.
Sure. And just to clarify on that, so the September 30th deadline is really just for the renewal. But if anyone were to apply this quarter, in order for it to be in effect by January 1st, they'd obviously have to get approved this quarter. But would they have through December 31st to get that approval at least to be in effect for January 1?
If they have the application into us, and usually we can turn around a provisional approval within a day or two, I'd say don't push the envelope to December 31st. You know, the 29th, 28th is probably the last time you really want to be if you're trying to get something for January 1st. I mean, it's a fairly automated process, and I think in some cases it might be instantaneous, but, you know, we do try to build a cushion in there of a couple of days.
Understood. Okay, we've got a few more minutes. We'll skip ones that we've already covered in some degree. This question regards the public program. For someone who's receiving the public program PFML benefits, and for a company where they also contribute towards the PFML contributions, the employees contribute, will that be taken out of the PFML benefit, their contribution share?
From our benefit?
Yes.
No. Those aren't wages under 151A. Our wages, like DUA wages, I don't believe, I'm 99% certain DUA, when you receive unemployment, it doesn't count on an employer's unemployment roll.
Understood. Thank you.
The next question, Bill, is should employers expect to spend a lot of resources assisting employees applying, or are the employees more or less on their own? And then related, what work is required on, on the company side to administer these leaves?
There's nothing in there that mandates any obligation of an employer to assist an employee with filing claims, although we welcome employers and employees that jointly file towards the effort here. The only obligations of an employer are to obviously have a poster, have them sign the acknowledgement, and respond to our requests. But no, I think it's a good thing if an employer can help out an employee and disseminate and distribute any information that they have. We, send out messaging through many forms and means, and in a lot of respects geared towards employers. We would hope employers would pass that down, information down to an employee as far as how to, what the guidance is on a claim. So we're looking and hoping that it is a joint effort overall.
Thank you. Hey, Ariel, I'm going to jump ahead to one of the questions that relates to that acknowledgement that Bill just mentioned.
Yep.
Bill, for a company that maybe has changed either from a public program to the private or maybe changed the contribution levels, do they need to send out the required individual notices again with whatever the new contributions or program are? And if so, do they have to collect that acknowledgement of receipt all over again? Because that got a little tricky.
We're not really looking for annual acknowledgments in the general context. So if an employer were once on the state plan and moved over to a private plan, we would hope that they would at least send out an update to the employees that, okay, the state plan has now been replaced by a private plan. Here are the provisions of the private plan. Maybe you would adjust your poster. Because obviously I think the department's information is listed on the poster, so now you would want to change that to whatever the carrier may be. So there's more of a housekeeping and updating standpoint. We We're not, for example, when we change or adjust the rates on an annual basis, it's not that we want or expect that employers will redo the acknowledgement because the rate changed. But with all of this said, it's important, again, policies of employers addressing these types of things that we can adjust as the state plan does, and we will provide notification in the following means when the state plan changes.
Thank you, Bill. I think we're at 3 o'clock. We've got about 4 more questions. Do you have a minute for 4 more? Or
yeah, you can let them rip.
Okay, Ariel, you want to ask that next one under FMLA?
Sure. So if an employer cannot obligate an employee to use paid family medical leave, could they use FMLA first, exhaust their time allowed under FMLA, and then use paid family medical leave?
We would look back to the FMLA usage, even though it's unpaid, and say, is this for a qualifying reason? And then we would deduct accordingly.
Thank you. Very helpful.
Thank you, Bill. On the topic of remote employees working from home, one company had employees in Massachusetts who are virtual and they don't have a physical location. They asked what the best way for them to manage Pfml is with respect to remote employees. It's kind of a loaded question, obviously, but with respect to posters and other things, is there any suggestions the department has for virtual employees?
We haven't really come out with anything specifically, but I would just say that to email them a copy of the poster, the acknowledgement. If the employee's residence is their office, then you furnish them with a poster for their office. Yeah, that's, the acknowledgement is obviously important, but, if it's a new employee, they need to sign it. And the employer's policy will determine the method of signing, electronic or otherwise.
Electronic is sufficient.
Yes.
Okay, great. Ariel?
Yeah. So if this question is, if an employee worked in New Hampshire for a New Hampshire company, but has been working from home in Massachusetts for the New Hampshire employer since March due to COVID-19, does the New Hampshire company have to start complying with the Pfml law? And I think we believe, Bill, from your from announcements from your department, that if it's a temporary situation due to COVID, they would not be subject to mass Pfml. But if the change becomes permanent, then they would become subject to the Pfml. Is that accurate?
I think that's the DOR. Taxation, interstate tax rules. We are going to remain with our number one response. Where is unemployment being paid? So if there's a change to that, then likely there's going to be a change to contributions.
Yep,
that's a helpful rule, because a lot of clients have asked that question. Should we really be thinking of where's unemployment paid as the real determinative question when we get in those gray areas? So that does help.
Yeah.
And this may be a similar answer for the next question. At what point do employees temporarily working out of state lose mass Pfml eligibility? Is it when the employer starts to pay taxes and unemployment to the outside state?
Unemployment.
Yep, I knew you were going to say that, Bill. Maybe perhaps our last question.
I've got one more after that.
Oh, sorry, go ahead. You got one more after that, Dan? All right. So we got this question. We got actually a couple of questions about the website, but one question was, will the department redesign the website? A number of folks commented that sometimes it's hard to know sort of what has been updated.
Yeah, I've been trying to address that through, for example, what's new right at the top. We're working on it. We realized, especially where we're going to be coming out with a lot of information in the upcoming weeks, that employers and employees are going to want to know what's new and fresh.
Yeah, I think that would be really helpful. And then, Dan, before you ask your last question, a number of folks on the webinar today asked, I think, a basic but important question. A number of folks still don't quite have clarity on how they access the portal or how to direct their employees when it comes time to make claims to access the portal.
That will all be coming in the next couple of weeks. Links. And it's also, we'll be sending out emails. It's live, the portal's live. You can log in, you can go to our website, and you're going to see the two links, employee-employer portal. So they'll all be there on our website. They'll have their own URLs, though, so that you can go right to those without coming to our website in the future.
And if I understood correctly, it's the employer portal is up. It's the employee portal that's not quite up yet. And then the employee portal will be
we're not accepting any claims right now from employees, so we don't want to set up any false hopes that you can apply now.
Sure. Okay, last question, I promise. For companies on a private plan dealing with the benefits to a separated employee, within 26 weeks after they're gone, is a logistical concern, I guess is a good way of putting it. Will there be guidance coming out to help employers with private plans on how to handle those requests from separated employees and either determining financial eligibility or just communicating with the former employee in a private plan?
We addressed this in the regulations that we came out with over the summer. I'm hoping it specifically addresses those concerns where if an employee has been terminated, they can apply for benefits up to 26 weeks, as we know, after separation. Where are they at that point that they apply? Are they still unemployed, or are they newly employed? So, for example, if an employee was separated from an employer that had a private plan, and during week 15 they need to apply for benefits and they're not employed, then it would go back to the private plan. But if that employee during that 15th week is now newly employed, then the claim is addressed under the new employer, under whatever plan they're under, whether it's a state plan or a private plan.
And I think part of the concern for the private plans are, how do we know when they get that new employer or have that, I guess, that trust factor in? And maybe that's not the department's, concern necessarily for a private plan, but there's that concern of, employer versus former employee to be informed and fully updated.
I guess it comes down to what are the protocols and practices of applying for benefits under a private plan, and are part of the rules of the private plan that we get to ask you if you're still employed, or rather you've regained employment. I'm kind of just talking off the cuff here.
Sure.
But I know in the context of, applications to us, we have a separate process for individuals that are unemployed. I think those claims are coming in initially, at least through our call center and not through the portal. And, we'll certainly be asking whether or not they're currently employed. I know that we will be, and who was their former employer.
Thank you, Bill. Well, that concludes all of the pre-submitted questions. We really appreciate you staying overtime with us and all of your time and attention to this. It was extremely insightful. I hope our audience appreciated it as well. I'm sure they did. And thank you, everyone. Have a great weekend and a happy and healthy holiday season to you, Bill, and to everyone that's participating. Thank you.
Thank you.
Thank you, Bill.
Bye-bye.